So I'm Miluwit Laksa. So I'm gonna say Simgaget, Sigamanak, Kupa Wolsitu. And so what that was to all the chiefs, to all the chieftainesses, and all the precious little ones. I said my name, and it says means that he who dances in the sky. And we're gonna say some words of gratitude now. Great Creator, we just pray to you and thank you for all things. We praise you for your grace, your love, your patience, your understanding, your strength, your teaching, and your protection. We thank you for helping us remove all our blocks so that your work flow through us to your grace and your glory, while we remain humble and respectful throughout. We thank you for the food we eat, the water we drink, the loving hands to prepare the food. We thank you for that opportunity for us all to get there, come together here in circle. For those that are out in internet, we thank you for being here with us. And we look forward to all the information that's going to be shared today. We ask us to be nice and gentle with each other. And we also know that we are not here to talk about our story. We're here to find out information on how to go forward with the 60 scoop. All my relations. Okay.
Thank you, Michael. Greetings, people. Welcome. My name is Pamela Abraham. My chosen name is Reagan Song Gargan. I'm with the 60 Scoop Indigenous Society of British Columbia, and we have the pleasure of hosting some lawyers from Ontario who have agreed to come and share what our rights and our options might be. So that would be Simona and Ivana.
Yes. Hello, my name is Simona Jelinek. I am senior counsel at Jelinek Ellis Gluckstein. We are lawyers based out of Toronto, Canada, but we are able to practice in other provinces, and we have partnered with other lawyers in other provinces to help. The reason why we're doing this is to bring information and awareness about what is available to 60 Scoop survivors over and above the 60 Scoop class action settlement that I'm sure most of you are aware that gave 60 Scoop survivors, or at least some of them, a sum of money. I have had the honor and the privilege and the pleasure of dealing with a variety of Indigenous clients from so many different nations since almost the day that I finished law school. Actually, even in law school, I was chosen to represent a large portion of the residential school survivors from Walpole First Nations, which is in Southwest Ontario. And I've had Indigenous clients throughout my career, almost 30 years now. And I'm very happy that we were given the opportunity to come and talk to you and to bring you this information. Ivana?
Hello, everyone. I'm Ivana Iwasaku. I'm an associate lawyer at Simona's firm. I live in Cambridge, Ontario, but same as Simona. I work all across Canada, and I work with other lawyers all across Canada. I'm here because I'm one of the lawyers that often has day-to-day management of these kinds of files. So if any of you wanted to come talk to us or ask us to help you with any of your justice or healing journeys, then I wanted people to meet me and know who it is that they're talking to on the other side of the phone. And before we go on to the next step, I just wanted to thank Elder Michael for words of gratitude for being here today.
Listen, thank you. Okay.
And if anybody else would like some, we also brought some more tobacco ties for everybody.
Maybe share what tobacco ties are.
Oh, yeah.
Just share
What tobacco ties are?
Yeah. Just briefly.
Tobacco ties are, tobacco is for requests. So they are honoring the people that have attended with tobacco. Thank you for attending, and the way of saying thank you.
This is friendship and peace and friendship. So we go into whoever we're doing that for, they honor us.
Thank you.
My son's given tobacco to a regional chief from BC. About 15 years ago, we met. Yeah, we had a meeting, and he said it was a professional meeting, and he said we're not at that point yet, so no. And so I've learned. He said once we're at that point, then we can do that. And I've kind of learned that I don't have to accept it until I'm ready. Is that okay?
Of
Yes,
course.
absolutely.
Yeah.
Yeah.
And I learned that. Yeah.
Yeah.
No,
Thank you.
it's okay.
It's offered, it's a gift offered in friendship only, and you do not have to accept it whatsoever. We also wanted to do a land acknowledgement. So we acknowledge that the city of Vancouver is situated on the unceded traditional territories of the Musqueam, Squamish, and Tsleil-Waututh nations. Vancouver is located on territory that was never ceded or given up by anyone to the Musqueamish, the Squamish, or the Tsleil-Waututh people. The term unceded acknowledges the dispossession of the land and the inherent rights that the peoples of this location hold to this territory. The term serves as a reminder that these people have never left the territories and will always retain their jurisdiction and relationship with the territory. And we further want to acknowledge the injustices that continue to plague the Indigenous people of this country, and we hope to continue to do the work towards reconciling the relationship with the people who are here and us, your guests. Thank you.
Thank you. Beautiful. So how are we going to proceed?
How many people are live?
We have five people on Zoom.
Okay.
So what we'll do today is all about giving you information, and we've found that one of the most interesting ways to present that information is in a question answer. And we have some questions that we have been asked many, many times. So we're going to start with those questions, and then if at the end we haven't answered something, then you're more than welcome to ask specific questions. But this is generally how we've done it. So okay, take it away.
Well, first question is this a class action?
Absolutely not. This is not a class action. Class actions are designed not for abuse cases. There's been a lot of class actions that have been for abuse, but originally they weren't designed for that, and therefore they're actually quite difficult to do in many abuse cases. And specifically in with regards to the 60's scoop, you actually can't do a class action because there isn't just one individual bad guy, if you will. There are lots, because the federal government, the government of Canada, downloaded the responsibility of Indigenous child welfare to the provinces. And each province has a different child welfare scheme. For instance, in Ontario, we have what are called Children's Aid Societies, and there are 16 or 17 independent Children's Aid Societies. Here in British Columbia, you have the Superintendent of Child Welfare. In other provinces, you have something else that is called something of that ilk, depending on which province. They all kind of do the same thing, but they're separate. And therefore, it's next to impossible to sue as one. The other thing as well that we feel that is not beneficial in a class action is that child abuse, any kind of abuse, but child abuse, sexual and physical abuse, is really about what happens to the individual, not the group. And in a class action, you are part of a group, and your voice is not really heard in that class action, because it is not up to you as to what happens in that class action. What it is that happened to you becomes just pushed into this big box and nothing else. Child abuse and the horrible consequences of child abuse are individual, and what happened to you is different than what happened to you and you and you. And that means that the ability for you to stand up for yourself, to tell your story, to be heard, to be understood, that is not what happens in a class action, but it is what happens in individual lawsuits, which is what we're talking about now.
Do-
Like we ask questions around a circle,
When we're finished answering these ones, if there's still questions left,
or you're reading
yes, I-
something?
Yeah,
Oh,
there's-
I didn't know you're reading something. So,
um, if I receive settlement money from the class action, can I still file and claim for abuse?
So yes, so that's part of the reason, that's actually the big reason why we want to go around and give this information to people. So it's become clear to us from the people that we've talked to that the class action did not make clear that the compensation you receive from the class action is just for loss of culture and family identity and family connections and things like that. It did not compensate you for if you suffered harm or abuse or trauma while in care or after being adopted by like a teacher or a priest or a coach or anything like that. So it's really important for us to say that because people who especially experienced abuse, especially things like physical and sexual abuse, they can receive a lot more possible compensation than any class action could give you, and definitely more than this class action did give you.
If the abuse happened a long time ago, can I still sue?
Absolutely. In most jurisdictions in Canada, British Columbia being one of them, there is no limitation period for suing for sexual abuse. So if the abuse happened here, there really isn't an issue to sue, whether it happened 5 minutes ago, 5 days ago, 5 weeks ago, 5 years ago, 50 years ago, you still have the opportunity to sue.
What is sexual abuse?
So sexual abuse is at law defined as any kind of non-consensual touching on a sexual part of your body or touching from another person's sexual part of their body on your body. So the key word there is consent. So children cannot consent to sexual contact. That's just a fact. And in some situations where especially there is a power imbalance, adults may not be able to consent to sexual contact either. So a great example is between a doctor and a patient. If a doctor touches you in a sexual way, that it may be that you, even though you're an adult and even though you didn't say no, it's still not considered consensual. And so therefore it would be considered sexual assault. Sexual abuse is often the term we mean to a long-term period. So went over a couple of days or a couple of months, couple of years. But even if it was one single instance of sexual assault, even if it happened many, many years or even decades ago, the lack of limitations period on those kinds of claims, even if it only happened once, you possibly still have the option to seek compensation for any harm you suffered as a result.
So what is institutional sexual abuse?
So institutional sexual abuse is when we are able to hold an institution in law responsible for what happened to you. Clearest example, if you were sexually abused while in foster care, so let's say your foster father sexually abused you, it's the institution that put you into that foster placement that we can, in some situations, hold responsible. So
What about the adoptees?
possibly as well for adopted, possibly for adopted, possibly for foster, possibly for teachers. I say possibly because there is no one size fits all. So in order for us to be able to tell you what we can do for you, we need to know a little bit more about your individual circumstances. So in many cases where there is an institution involved, we can at law hold that institution responsible, whether it's the child welfare organization or the school board, for instance, if it was a teacher that sexually abused you, or the church, if it was a priest or a Boy Scout, Girl Scout, whatever have you, whatever the institution was. With 60's scoop survivors, we're more often than not talking about child welfare agencies, whether it was you being placed in a foster home, an adoptive home, a group home, whatever kind of setting. In some situations, we are able to hold the child welfare institution responsible. I say some because as much as I want to say we can help everybody, we can't help everybody. In a lot of situations, by a lot, I mean a lot of situations, we are able to show how in law, the institution was responsible for what happened to you while you were in care.
May I ask for clarification?
Sure.
So for instance, if it's like you're in a home, adopted home, and you attended an institution, let's say like Brownies or whatever, is that what you're talking about? So it could be child welfare who may be responsible.
Or it could be the Brownies.
Okay.
It all kind of depends. Yeah.
And you would let us know that.
Yeah. I mean, that's a really good question that has a complicated answer depending on exactly what happened to you. So, again, the easy one, for instance, is that if it's your foster father, it's probably the child welfare institution. If it's the Brownies, for instance, it may be the child welfare institution and the Brownies, or maybe just the Brownies. I don't know. That's where we need to know so much more about what happened individually to you, and then we can outline what your options are and how best to achieve your goals.
So I think on that note, it might actually be a good idea to skip ahead a couple questions and
Yeah.
then let's answer this one.
Yeah.
And I think that will give a little bit more context. Yeah.
What is the process of going through an individual sexual or physical abuse case?
Go ahead.
So to this point, what I want to make clear is the very first thing that we do is when somebody contacts us to say, I was harmed in care, or I was harmed by my adoptive family, or I was abused, or whatever your case may be, the very first thing that we do, at least at our firm, and most lawyers do too, is they'll do an investigation. So when I do an investigation, I want to not only know what happened, but I also want to know what your life was like before you were abused and what's gone on since, how it's affected you, where you are now, all that kind of stuff, because that will give me all the information that I then need to know what your options are. And I often say, and I'll say it again, I often joke that I need every single piece of paper ever made about you in your life, but that's actually not far from the truth. Because when somebody's abused as a child or sexually abused, it affects your whole person. It's not just physical injury. It's an emotional, psychological, and spiritual injury. It affects your ability to work, your ability to form romantic relationships, to be a parent, to be a child, to show up for your friends, to go to school, to live successfully, to house yourself. So it affects everything. So at least for us, I need to know everything. Part of learning about everything is if, for example, you were harmed in, let's say, your adoptive home, I need to see your child welfare file, but I also need to see, did a teacher report to a social worker? Did a doctor report to the police? Did a social worker report to child welfare? So I need to know all of that, because then I will know what child welfare knew, what the school knew, what the police knew, what the hospitals knew, what the doctors know. And then I can say, look, did somebody know that something was going on? Should somebody have asked the question, is something going on? And from there, that's when doing that investigation, that's when we try to figure out who knew, what did they know, how much did they know, and what should they have done about it. Yeah.
A concern that I have is opening up, and then with FNHA, they don't offer counseling to 60's group yet, as you probably know.
Mhm.
So, I mean, there are a lot of organizations that have someone who has like a counseling certificate,
Mhm.
but not technically, clinical counselors.
Mhm.
So
I'm just gonna,
I'm wondering, in the province of British Columbia, I mean, I want to seek the help of a clinical counselor, not someone who has a counseling.
We have a new organization that just opened up in Vancouver, which is all Indigenous therapists,
What's it called?
Metro Indigenous Services.
Oh, Giselle.
I'm not sure who's
Giselle
running it.
Henry. Yeah.
No, that's not, it's a different, it's strictly, these are professional counselors. They're not associated with the society. I'll get your number and I'll text you that after this is over, but they are strictly Indigenous owned and operated, Indigenous trauma informed therapist.
And I don't want to take it, but
No.
I'm hoping that, I'm sorry, I know this lady from another society, and I really want my privacy to be private.
Mhm.
Is it possible that we only correspond with, say, the two of you? I'm not comfortable with,
Sure.
yeah,
So
is that okay?
So this is an information session,
Yeah.
right? We will give you the information. If you choose to contact us
Mhm.
and talk to us about your case, then that information is strictly confidential
That's
between
fine.
the lawyer and you. This is just
I
to
don't
share
want it.
information,
Okay.
you know? Raven Song and the other people that have helped us bring this information throughout Canada, they are involved only insofar as to facilitate getting people together, spreading the information that we're having these information sessions.
And helping us understand like which communities to go to and
Yeah.
how we communicate the thing to people, like they're here to help us get out to the community, but then after that, it's up to
The
you.
reason I have that concern is when Cindy Blackstock came forward about the Millennium Scoop,
Mhm.
I was working as an intern in the feds, and she had a lot of harassment. And I really worry like about my own safety by coming forward, how much privacy we have, because I mean, she's got an array of help to help her across the country. We as individuals in Vancouver and BC, especially when we have not had an apology yet, nobody really wants us, I think, my opinion, to come forward. So I'm actually feeling like scared. I came, but I'm also like, what kind of security do we have, say, with the Vancouver police, knowing that if we were to come forward, that we would actually have a go-to person saying, hey, this person's being like.
So here's the difference between a class action like what Cindy did, or what the 60 Scoop class action was, or the Indian Residential School class action, or whatever else. What you're doing is completely private. If you decide to reach out to a lawyer, whether it's us or other lawyers, it doesn't have to be us, it could be other lawyers. You are, as an individual, deciding to hire a lawyer to pursue your individual rights. So it is private between you. It's a civil action.
I thought civil becomes public.
It is, there's
knowledge.
a, if you file a statement of claim, that court document, theoretically, yes, it is public, you know,
Yeah.
if-
and that
if-
comes out every
different-
day.
different.
yeah. So it is public in the sense that there's a public record of it, okay? The reality of somebody finding that information, they have to really look for it and really decide that they want to find it about you. What we're doing here today and the kinds of information that we're giving is the kinds of cases that I personally have been doing for almost 30 years. There is no actual difference between suing child welfare, whether you're Indigenous or not Indigenous. There is no real difference in suing child welfare, whether you're doing it in British Columbia, Ontario, or out of the Maritimes. It's all basically the same. There are little slight procedural differences here and there, but it's all the same. The reason why we're doing this and the reason why we're bringing it to 60 Scoop survivors is that, okay, originally, the reason why this happened was that we were contacted by somebody who was abused while she was in care, and she was trying to find a lawyer to help her. And she was put in touch with me through a mutual friend. And in speaking with her, she runs the 60 Scoop
Network.
Thank you. 60scoopnetwork.org in Ontario, and she does work throughout Canada. It became very, very apparent that 60 Scoop survivors did not understand that that class action was only for the cultural harms that were caused. It had nothing to do with the fact that many 60 Scoop survivors suffered physical and sexual abuse in care. So in speaking with her, it was dramatic that we felt incumbent on us to say, hey, wait a minute, there's so much misinformation out there that we want to bring this awareness to these people that, hey, you know what, it's not just that 25,000 that you got from the class action. If you're abused in care, you have other options. This is what we're talking about. So it is you doing this against the government, if it's British Columbia, the Children's Aid Societies, whoever the defendants is, the Brownies, whoever it is, as an individual. It's a private wrong. It is not a public wrong. It is not a class action.
And I should, even if this court document is
Yes.
filed, there are other privacy tools that we can use. So there's lots of technical terms for it, but in effect, there's ways to hide your identity from that court document. So, and there's a couple of ways that we can do that. And then if we need to, for other reasons, we can even go so far as to try to get what's called a sealing order, which is where it's no longer public information. So there are other tools we can use to protect your privacy. And to that point, to the end, when we get to the end, most of the time, these cases are resolved out of court. So it doesn't require a trial, it doesn't require a public hearing. Most of the time, the only public document that exists out there is your filed lawsuit document, which we don't even have to put in your own name. We can put in, you know, a
Jane Doe,
pseudonym
whatever.
or initials or something else. Their response, which says, you know, this is, we deny, it's going to say the same thing every single time. We deny that there was this problem. We deny that we did anything wrong, blah, whatever. And then everything else is done out of court, just between the lawyers. Most of my cases happen by email, by fax, and by letter, and that's it.
And you hardly ever get to actual trial.
I feel sad that, I feel sad that BC hasn't offered us an apology before doing this. So I'm wondering, I know like I've recently had a human rights, and part of that, I think I was able to request what I would like besides compensation.
Mhm.
Can we be requesting an apology along with compensation?
Of course. So,
Because we're just not getting it.
so an individual lawsuit, a private lawsuit, is about one thing and one thing only, which is compensation. What we are able to get for you, what a judge can give in an individual lawsuit is compensation. And compensation is the symbol that we have to show that something went wrong and it wasn't your fault. The amount of compensation that you get, whether it's $1 or $1 million or somewhere in the middle, is not a reflection about how much your life is worth. It's not a reflection on anything. It is simply a symbol. And hopefully you can take that, a symbol that something went wrong and it wasn't your fault. Okay. And hopefully you can use that compensation to obtain healing, to do whatever it is that you wish to do, and hopefully it'll be constructive. However, the interesting thing about individual lawsuits is that they do, you know, they are tailored to you. So if an apology is really important for you, that can be a part of the negotiations within that lawsuit.
Mhm.
And for some people, apologies are really very, very important. And for other people, they don't care. You know, I've had both sides. You know, I've had some clients say, I don't care how much money I get, I just want that apology. I've had people say, I don't care about an apology, it's meaningless, I want the compensation, right? Everybody is different. We have also had situations where people want other things. You know, we had a case where it was against a church. It was a priest, and for my client, it was very important that she present to the class of priests. You know, the initiates, noviates. I can't remember what they're called, whichever one it was. She wanted to go and talk to these people that wanted to become priests and explain to them how much power they had and what happens if they abuse that power. And that was part of the negotiations, and that's part of what she obtained through the lawsuit. That is something that can happen in an individual lawsuit that cannot happen in a class action. So yeah, if you want an apology, that could be something that could be part of your individual lawsuit.
How is it different in the residential school? Because like, I guess their part of the abuse wasn't a class action, it was just individual.
Yes and no. Yes and no. As part of the Indian residential school settlement, there was a separate process, but part of the class action that was called the IAP, the independent assessment process. So in the negotiated class action, you had this two-pronged approach where if you went to a residential school, everybody got what was called the common experience payment. And it depended on how long you were at the residential school and this and the other thing. Everybody got that. If you suffered harm at the school, you could then apply separately to this independent assessment process. And depending on what happened to you, you could form part of that. You could go through that process. And for some people, that process, depending on what happened to them, was very short. And for some people, it actually ended up being a much more detailed situation where they actually had to go and talk to an arbitrator. And for other people, they actually had to get medical assessments and this, that, and the other thing. But all of that was still part of the Indian residential school settlement. So this is completely separate. The 60 scoop class action did not have that possibility at all. So we're we're doing this not within that 60 scoop class action, completely separate and apart from it, but similar in the sense that it is for abuse that was suffered while in care.
So you're two people, but do you have a law firm in every province?
So
Sorry,
my,
no, sorry.
No,
sure.
that's a good-
No,
that's a good question.
it's a good question. So my law firm, we have 5 lawyers that specialize in institutional abuse. So it's myself and four associates, Ivana being one of them, and I've got three other people with me. We have partnered with other law firms in Canada so that, for instance, if we have a case here in British Columbia, because we're not British Columbia lawyers, we're Ontario lawyers, the people here in British Columbia will do certain things and we will do other things because we have the specializations that of the institutional abuse and this, that, and the other thing, but we need the lawyer in the province to fill in the right forms in the court and to do things procedurally different.
Mhm.
So we are one law firm, but has partnered with other law firms throughout Canada.
Oh.
You don't need to come to us. You can go to whichever lawyer you want in whatever province you want.
Yeah.
Okay.
You know, this is a very specialized area of law, so there are not very many lawyers that know how to do this kind of thing.
So how can 5 people do so many people? If you're 5 and we're all across Canada,
Mhm.
I mean, how do you take on that many cases?
Lots of different answers to that, and it
Sorry,
really.
no, that's a good question.
No. It is a very good question, and there's lots of different answers. One of the answers is that we are actually pretty efficient at how we do these things. Okay, there is. Remember when I said that there's really no difference between how we do this for an Indigenous person and a non-Indigenous person because it's the same.
Yeah.
We've been doing this for 30 years. So we've got that system set up. We know what we're doing. We are really specialists in this area of law. Okay. But because we have also partnered with law firms in different provinces, we are able to offload some of the work to them.
Mhm.
So it may not be all of the work, the things that really require the specialization that we have, we may still do, but you know, the day-to-day running of things, we may offload to those other lawyers.
And it's not just the 5 of us either. We have
Yeah.
a bunch of support staff. So we have clerks and we have an intake coordinator and we have a records request clerk. So we have support staff that help us do some of that work too. So it's the 5 lawyers, but like there's a whole law firm that we come from. And so we have lots of support there
Yeah.
too.
The law firm itself is about 80 of us now.
I think,
It's a
we
big
have
law
an
firm.
Ottawa office and an Agra office and a Barrie office. It's like we have a bunch of offices in Ontario and the support staff there, you know, as are part of our team and other lawyers are there to help us if we need it. So it's that we're the core
group.
Yeah. And then we have these other partners that help us. So they, you know, if we need them to do some of the work, we work that out with them. If
Yeah.
you want to talk to us though, like I manage a number of cases every single year. I don't just manage 4 or 5, like I manage a number of cases. So I'm used to helping lots of people at the same time.
We're also very committed to make sure that if we need more people, if we need more staff, we will go out and find those people. They're not easy to find.
Yeah.
This is a very
Who wants
specialized.
to take it on?
Good point. So sometimes it is hard to find people, but you know, if we need more help, we have the resources that when the time comes to expand in that sense, if that is something that we decide that we need to do, we're committed to making sure that we can do it.
I was kind of
Hang on.
hoping that sorry, I'm even making.
It's-
No.
Carry on, finish up.
I was kind of hoping that somebody was gonna be here from, say, the Vancouver police, like even like because.
That's not what this is about.
No, I know, but I've known people who have had cases like this, who have, you know, had harm or had harassment and things like that. And, I mean, I find it, as a 60 scoop here in DC, like, there's a strong correlation between, like, I don't want to say it, like victim farm, things like that. Correlation of like missing and murdered women and people. And I just feel myself, I wish somebody was here, where it's like, is something, if there was any backlash, like, I mean, if I were to be suing one place, they would know where to find it. They may want to make it public.
There's no point to them to make it public. The defendants are not going to be the ones to make it public because at the end of the day, it's making themselves look bad. It's a public relations thing for them.
Are you worried because of Cindy? Cindy Blackstock, are you worried because of how she was treated?
Yeah, I mean, it was pretty bad. I mean, she had to get help from the police.
Look, we can't control what happens. We can put in place certain things, and experience tells us what generally happens in these cases. The institution itself is likely not going to be the problem. We've had situations where if you sue an individual, that individual may do something unfortunate, and that's something that can happen. You know, I've had individual defendants come after me personally because I'm suing them. You know, I'm the lawyer suing them, so they come after me personally. If that happens, it happens, and we will put in place whatever it is that we can to protect the people that are involved. But what it is that we're trying to do here and the information that we're giving, this is something that we have been doing for decades, suing child welfare for how they mishandled their wards is something that I've been doing since 1998. So it is something that unfortunately we know happens. We put in place what it is that we need. But because this is not a class action, you're likely not to see the kind of things that happened to Cindy Blackstock.
I mean, for what it's worth, before I came to Simona, I spent a couple years as like a civil litigator. So I spent a couple years doing things like defamation and employment and human rights and breach of contract and breach of privacy. So I'm used to helping manage those kinds of things. Like I had a case last year where somebody was being harassed online, and I had every single one of those posts taken down because my client wanted her privacy protected and I had her privacy protected. So there are also tools that we know how to use to make sure that people don't, as much as we can, don't experience a lot of blowback or other re-traumatization because of it.
Not to try to cut you off.
Yeah.
Cindy Blackstock is actually my cousin, so I'm really aware of that situation and what you're speaking of. What she's going through is way different from anything you ever would go through, right? She's been attacked by the government. The government's not going to attack you, okay? So we're talking about apples and oranges. Because she's an orange, they're going after her, right? But for us, whatever we're going to do, we'll do what we're doing. And so what we're looking at, why am I standing here? Who am I? So they recognize that we as First Nations, we are a little bit careful about, excuse me, the expression here. We're careful about what we do with the white man, right? Right? We're dealing with two people here that look very white. So we're very careful about that. So because I'm a medicine person and I've been doing this work for a long time, and I know that I'm here to make sure that this is a safe space for you. I'm here to make sure it's safe here as well. I've been working with MCFD for years as a Star Elder through Surrey. And that's the same thing when I go into those meetings, I'm sitting down and we're doing a lot of cases with family, and there's a lot of pain involved in there. I'm there to make sure that the family's looked after and the social workers and all the intake workers and everybody else, they're looked after as well. And from time to time, I stand up and I speak my piece. Sometimes we'll have a family member standing up and being really rude. And it's rude because of their past history. So what we have to do is we have to get past the past history, bring them back and say, what are you doing here? You're supposed to be here fighting for your child, not talking about your past history. So I've done many things, and I've got a lot of experience in that. And when I got the call to come and be part of this, I'm bringing a lot of experience. I'm good. I have people around Canada, even the States, that I contact in different ways. And if there's a problem, I can reach out to them. You know? So I understand your concerns. But by the same token, as you go through, if you go through the process, a lot of those concerns should be relaxed.
Okay, can I respond?
Okay.
After the 60's group, my whole adoptive family, besides my dad, cut me off.
When you say the 60 scoop, do you mean the class action?
They cut me off.
Right, a lot of us lost.
And people in the, I'm from a small community, and everybody knows that I was part of the class action. And I lost so many friends. So I hear what you're saying, but from my experience, like the what's the word I'm looking for, the feedback from participating, like one family member who talks to me.
Yeah.
And the rest
So-
of them I don't have a, sorry. So
I-
that's what I'm saying.
That's a
is that-
community standard that you're fighting against. That has nothing to do with what's happening here.
No, but I think it's good to know what other things that we're bringing about our communities,
Mhm.
if that becomes public knowledge towards the one person who is your support system. That's what I'm wondering is, will it be private so that,
We can make it as private as we can. We can shield your name. The defendants will not share your name. Okay, there's no doubt about that. If somebody decides to go to the courthouse and look at all the documentation and they can somehow piece together that it's you, even though it's your initials or Jane Doe,
right?
if they can piece all that together, if they're that good a detective, yeah. Is that gonna happen?
You need to
No.
hire them.
We need to hire them at that point.
So I've been involved in a lot of communities in my lifetime, and your situation is different from most communities. I mean, I talked to, I have a lot of relations in the Gluckstein Nation, and so I was talking to different ones about their situation. When we brought up the day school, so I'm talking to one cousin, she says, I got $10,000 for that. And I talked to another cousin, he says, I got $150,000. There's disparities all over the place. And the government wants to make communication and people be upset at each other. And so the fact that you stood up for yourself, which you should do, and then your community chose to give you a difficult time, that should not have happened, but that's a community affair. So like they say, they're going to do everything they can if you choose them, because we don't know what the other lawyers are going to do. But they're saying to you right now that they'll do everything possible to protect your identity. Okay?
And likewise, if somebody wants their name to be heard, we can do that too. Because for some people, having their name heard is part of their healing.
So if it's important to you that it be a very private matter, like we can even try before we file a public document, we can try contacting child welfare just with a letter, and a letter is completely private and confidential. And it's important to add, like, this process is up to you. We're here to give you advice and suggestions, but and so let's say the first thing that we try is this letter, and the letter doesn't work out. I say we need to file a public document. I have one client that wants nothing to do with the lawsuit. She doesn't want anything out there in public. And I said, that's entirely up to you. I'm here to tell you what I think your options are, what the best, strategic advice I can give you is, but at the end of the day, you're the decision maker. So it's the process where we try to make the process suit each individual as much as possible too.
You've been itching to ask a question.
Yes,
So you talked about lawyers
yes.
across Canada.
Yeah.
So my question is, I'm coming into territory, into a meeting ahead of time, trying to bring it back to Mi'kmaq.
Right.
So do you have lawyers in Mi'kmaq yet?
We do.
We do.
You do. Okay, so can we talk later and you can give me their names?
Yeah,
so
of
that
course.
we can talk? I
Yeah.
can let other people.
Yeah, we can talk about that and we can sort of explain what it is that we're doing out there.
Yeah.
Yeah, for sure.
Because I would like to be able to, make the contacts.
Yep, for sure. For sure.
Oh, okay, because I thought it would just be you guys that we were dealing with, the Mi'kmaq. I
It-
didn't know that there was where I was in, it had nothing to do with me as an Aboriginal Illinois, the 60s school,
Mhm.
but it had to me being in that institution.
Mhm.
And we sued the province and that institution.
Mhm.
Okay, so to go back, I'm not sure if I can go back as an individual,
Yeah.
but that was a class action.
Right.
This is non-class action.
Yeah.
This is
This is
individual.
what I'm hearing. So basically, it shouldn't apply.
Well, that's just like we talked about,
Yeah.
it will depend on what you signed and what it was that you did. So I need to learn a little bit more about that before we can give you an
I
answer.
didn't realize what I was signing.
So we can
because-
talk about those specific options
so
then.
put that, you know what I mean? And they just put it across the board. It's just-
Yeah.
I'm sure you've dealt with other people, the only people that have other lawsuits go on and have the.
Oh, yes. And, you know, I have to know, so that's.
Elderly means people are mad, sorry.
No, that's okay. That's part of why I have to know a little bit about almost everything I can about you, because, you know, it might be that that option ended when you signed that piece of paper, but it might be that there's other smaller options or other pieces that we can still work with. So it's hard for me to say without knowing those specific details. Just like it would be hard for me to say we can hold child welfare responsible or the police or until I know who knew what and how much. So that's something that I would have to look at specifically, but you know, as we learn more, I may be able to give you better answers. But for right now, what I think it's important to emphasize is we wanted to let people know that they should at least ask the question, right? They should at least try if they're ready for it, if they want. We don't want people to feel discouraged or deterred or like the option's gone away from them just because they signed up for the settlement. So we want people to know that you can still at least ask the question.
So part B to my question too is, our story, if my story has already come out before,
Mhm.
so, and I have it on paper already,
Mhm.
written out, instead of sitting there and re-traumatizing, because to me, it's re-traumatizing over and over again. I'm trying to tell my story as a child, 60's school, it's my spirit, where I'm trying to heal. I know that it takes a long time to heal, right? But it's opening the doors. So I have my story already. Pass you that papers and come back to me with my story and say, well, we.
Yeah.
Without me having to verbally my story over.
Sure.
Again.
So, so the beauty of an individual lawsuit is that we try to make this as easy.
Yeah.
Okay. And what might work for you might be you and what works for you and what works for you.
Right.
So if you've got it all written out though, that's a really great start. You know, what's written there may be everything that we need, or it may be 90% of the things that we need. And we'll only come back to you for X, Y, and Z, right?
So part C of this question
Sure.
is, so we're going after government papers,
Mhm.
right?
Well, that's the first thing. Yeah.
So. Government papers. Just like it's just rules,
Yep.
the paperwork, you know, stuff.
Yep.
That's gone all of a sudden, missing.
Yeah.
Can be.
Yeah.
So what happens when the government says, no, that's not the way it happened, but we don't have the papers to confirm this?
You'd be surprised at what happens when lawyers get involved. All of a sudden they find papers.
Okay. Just curious.
Look,
Because it's one of the
Yeah.
questions that I can assure people that, you know, a lot of your paperwork come up, we can't find you no more. We don't know
So-
where.
That's so funny.
yeah. So look, you know, when you put in a request for your paperwork, right? Whoever the clerk is that's looking for it is going to go, where is it? Can't find it, whatever, right? That's it. Sometimes they'll find it. Sometimes they'll find this much of it. Sometimes they'll find the whole thing. Sometimes they'll find nothing. When lawyers get involved and there's a lawsuit, all of a sudden everything comes out of the woodwork because all of a sudden the stakes are much, much higher. You know, Ivana reminded me of this one case where when the defense lawyer it was a Catholic Children's Aid Society, actually, non-Indigenous. My client was non-Indigenous, and at first they couldn't find her paperwork or his paperwork. His paperwork. Sorry. sorry, in 30 years of doing this, I've had quite a few of these. And the lawyer contacted me. Is a lawyer that I've worked with many, many times before. He's one of the defense lawyers that we generally work with. And he said, you know, we only have 20 pages of information on your client. Sorry, we don't know what happened to the rest. We're going to keep looking, blah, blah, blah. And, you know, he kept looking for it because we all know there's more information. Anyway, turns out that they actually did find my client's file because Barry's daughter, who was working at the law firm, his law firm, for a summer, found it in a box on top of a filing cabinet. So the paperwork is there.
Yeah.
You just have to find it. Okay.
When I got my paperwork for the last lawsuit, I had from the community services, they had black marks on them too. Black marks,
Yeah.
black marks,
So
black
that's
marks.
normal. That's
Yeah.
normal. Okay, that is normal because what happens is that there's privacy privacy legislation. So it's not that they don't want to give it to you. They can't give it to you because it actually impacts somebody else's privacy. Okay, so that's why they can't give it to you specifically. They can still give it to us.
Oh, okay.
When we get the information, some of it is still blacked out, but a lot less.
Yeah.
And if it's something that's blacked out that we think is really important, we can actually go to a judge and have that judge decide whether or not the information that's blacked out is actually important to us or not. Sometimes it's not, and who cares whether or not it's blacked out? Sometimes it's very important and the judge will allow us to look at it.
Yeah, a good
Yeah.
example is if it's about your brother or sister,
No,
your,
it's like institutions, this person said this about Miss Gilbert's behavior and blah, 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 and they have that blocked out and it's a social work,
Yeah, and
right?
and there are reasons for that. That information from that social worker would not be blocked out in our version of it.
Would you have, sorry. If you can see it, can you tell us?
Yeah.
Wow, if you can get it from down, I'm interested in that part. Yeah. 'cause I
Yeah.
know my file has a lot
the
of
way that we request it though is we have to do it inside of a lawsuit. And the reason for that is because there's different rules that apply. So when you request your file, it's what, I don't want to say anyone's name, but it was what was mentioned earlier, which is the freedom of information request. That's one set of rules with one set of requirements for privacy protection and one set of requirements for what they have to give you. When there's a lawsuit, it's a different set of rules. So typically what the request that we make, the request is made inside of a lawsuit. So that's typically what happens. So, but like I said, we work with everybody to try to make sure that their options, the lawsuit process or their options work for them.
I don't know if this is a question, if you can answer it, but like,
Yeah.
for example, go to RTA. You might be fighting for like 10 months for like $1,000. And I've done it and it's like, why did I do that? Because technically, if you think about
The
it,
time.
took 10 months, right? And that's how BC is, right? And I've done another one with human rights, not a public person, but like, same thing again, gone out long, and then they came back and said, we can only go this high. I know you can't answer this.
How much is your case worth?
No, I mean, what's a ballpark that we're looking at, knowing that this is a fight that's, you know what I mean? I don't want to go and be like, oh, well, we're looking at 10 grand. I'm like, well,
Sure.
I don't know if that's a good question.
It's actually a really good question that has no good answer because the amount of compensation that's available is really dependent on so many individual factors. It's dependent on what happened to you, and it's dependent on the consequences that it had on your life. So, you know, while two people can have had the exact same thing happen to them, physically the exact same thing, how you've dealt with it and how somebody else has dealt with it is very different, you know? So because we understand and because judges are getting much better at understanding that childhood abuse, especially sexual abuse, has lifelong bad impacts on people's abilities to interact with other people, on people's abilities to go to school, on people's abilities to hold down jobs, to progress in their jobs, all of that, judges are becoming better at understanding that the impact of child sexual abuse is also on your ability to earn income. And, you know, that is also dependent on, you know, what where maybe you would have gone but for the childhood sexual abuse, how much better or worse off you are than your family members, all of those kinds of things. There are so many different factors. But to give you a ballpark, childhood sexual abuse can, the compensation that is available can be even more than $1 million. It could be 10,000. I doubt it. It could be 50,000. It could be 200,000 or 300,000. It could be $1 million. It could be $1.5 million. It really does depend on those individual circumstances. If we know more and when we know more about what happened to you, we'll be able to give you a better ballpark.
And would it come for those that are on disability in the provinces?
Mhm.
Will we lose our disability?
It depends on which province. I can very definitively tell you in Ontario, you would not lose your disability. In British Columbia, I don't think you do either. In some other provinces, it's a bit of a gray area, but I believe you're correct that in BC, you don't lose your disability.
When I look through the list, I see that it says 60's scoop would be exempted. And then it had specific cases like Niska and that, but I didn't see one.
This is different because it's not part of a class action. You don't,
No, I know.
it's not a question of whether you fit into the 60 scoop or this, that, or the other thing. It's totally different.
So what does it fall under the exemption? What do I look
It
for?
may fall under pain and suffering or something called general damages.
Yeah.
Okay.
Yeah.
You saw it?
No, I've been working as a nurse for 35 years in BC,
Okay.
with clients that are on disability, don't lose your disability.
Yeah.
Okay.
So with all due respect, we've gone way off track, which is
Yeah.
okay, because we're covering a lot of the stuff we're covering.
Absolutely.
Yeah.
But we'd like to get back onto the program so that
Mhm.
a lot of the questions you're
Yes.
asking are going to be brought up. So if you kind of hold back on
Yeah.
asking too many questions, probably find at the end of the meeting, they'll cover most everything you want to know.
Yeah.
So if we can go forward.
And on that note, we should
Yeah.
actually finish talking about how a lawsuit works because we
Went off track.
we went off track after you talked about in the investigation.
Yeah.
So after the investigation, what do we do?
Yeah, so after the investigation, if the best option, and often the best option is for people to start a lawsuit, we'll do what we discussed. So we'll file a piece of paper with the courts that will say what happened to you, when it happened, who was involved, and we'll name defendants. We can name you as an individual if that's what you want. We can hide your name, whichever is best for you. Then we'll serve all the defendants. So it could be, for example, child welfare, it could be the abuser, it could be Girl Scouts, whoever it is. They contact us. We typically have an initial off-the-record, private, confidential conversation. Me and whoever, maybe it's the lawyers, maybe it's the directors of whichever people we've sued, to discuss, is it possible to have a resolution now, or do we need to do a little bit more work? Typically, we need to do a little bit more work. So what that work looks like is, how earlier I was saying I need to collect basically every single piece of paper about you. So that then becomes the evidence that we use as part of the case. So we collect all of our evidence, they collect all of their evidence, whatever it might be. Maybe they have child welfare files, maybe they have a file on your adoptive family, maybe they have files on your siblings or foster siblings. They collect all of that and we exchange it. And that's not filed with the court either. So that's just something that they send to us in a file box, we send to them in a file box or by an email, and then we each have a chance to look at it. And then typically after that, the next step is the defendants bring you in because they'd like an opportunity to ask you some questions. So at this point, I've had a lot of experience to say that most of the time they'll want you to go through everything that happened, but not always. Sometimes they'll say, well, we don't need to go back through that because, I have something from a police statement that says it already, or another proceeding over here that says it already. So it will depend on what's written down and how it's been written down. But typically they do want to bring you in for some questioning. A large part of the reason they want to do that is they want to see who you are and they want to hear you say for yourself what happened to you. And they want to hear for yourself how it's affected you. And that can be really powerful, not just for them to hear, because now they've had a chance to actually see how things have affected you. But sometimes we find that clients find it really powerful for themselves. It's a way for them to stand up for themselves, or a way for them to make the people that failed them face the consequences of their actions. So a lot of clients do also find it, scary, and it can be difficult, but it can also be hugely
Therapeutic.
powerful, yeah, as part of the healing process.
Yep.
So, you know, that's a step that we prepare you for really well. So we take you, we have a long meeting with you, we let you know what to expect. We go through just about every single question I think I can anticipate as best as I can. I'm not that lawyer, but you know, I have a good feeling about typically what they're going to ask about. So, and so we make sure that you're as equipped as we can. If people need, you know, support, we make sure they have support in place. If people need to, you know, plan for what they do the next day or the next week afterwards, you know, we'll do that too. So try to minimize the difficulty as much as possible.
So when we were doing 60 scoop, I was called in as an elder, and I would work with the family. I wasn't working with the panel, I was working with the family, so that you're not gonna run into a situation where you're not able to speak because of your emotions and all that. Part of what I do, and someone else who does what I do, is to help you stay grounded, and help you to, and if you need that moment, I have to be able to call a moment. You know what, we're gonna take a recess, we're going to have a smoke, or we're gonna have a coffee, or drink water, have a good cry, whatever it is that we need to make sure that you are satisfied so that you can carry on with the work you have to do.
So you're saying you're gonna be present?
I don't know.
No,
That's an example.
but that's an example.
Yeah.
So in every case, because every case is different, if you, for instance, really need your elder to be there with you, let's say, okay, we can negotiate that with the defendants.
Mhm.
You know, I had a situation where my client really needed her dog.
Okay.
So we had her dog there with us, you know? We have situations where people, you know, want their spouse to be there with them, but maybe not in the same room, but to wait outside, right? Everybody is different.
I
So
really appreciate you saying that because like, you don't have to have somebody who's indigenous, it could be somebody who's non-indigenous.
it can, yeah,
Okay.
it can be exactly. Individual lawsuits are exactly that. They are individual. What works for you may not be what works for somebody else. When you work with us and we understand what it is that you need, we will do everything we can to make that happen.
Mhm.
Sometimes we can, sometimes we can't, but if we can't completely, we can usually find a workaround.
That's
Yeah.
awesome.
And for some people, you know, yeah, they absolutely want their elder to be there. And maybe their elder can't be in the room with them, but can be waiting outside. And we can have regularly scheduled breaks.
Yeah.
Or, you know, oftentimes when there's these examinations, emotions are high. So we are able to take breaks.
And you help us find somebody.
If you need us to help you find somebody, we will do that. A lot of people already have who it is that they want to go to. But if you don't, we will do what we can to try to find you somebody.
Yeah.
Back to the process.
Yeah, so questioning. So after questioning, and I want to say, as part of you being in charge of the process, there are some steps you have to take. You know, there's some procedures and rules that you have to follow, but part of working with you is, like Simona was saying, if you want to take a scheduled break. I had a client that we needed to stop every half hour because she also had leg and hip pain. So every half hour she needed to get up and just go walk around for a minute. And that was totally fine. So once that's done though, once that's passed, I then typically have a second conversation with all the defendants. And then we say, okay, do you have enough? Can we settle this? Can we resolve this? How can we work this out? If they say, yes, we can resolve it now, great. If not, typically the next step is then to actually go to mediation. So mediation is a private, confidential conversation between us. So us being you and your lawyer, and the defendants and their lawyers. And it's facilitated by typically another lawyer, sometimes a retired judge. We actually have a specialist mediator who lives on the island, so she works with us all the time. And they help create not just the space for the conversation, but they help create the steps necessary for actually resolving that, if they can. And we have a lot of success with settling cases at mediation. So mediations are not only confidential, so anything we say during the process or they say during the process, that stays there. That doesn't go to court, that doesn't go anywhere else. The settlement can also be confidential. So there's no paperwork anywhere that says, you know, you received $1,000. So your family's not going to be able to find it. It's not going to be on the internet. It's a private settlement. Just like if you want an apology or if you want something else or how much money somebody paid you, all private. And you also, at that point in a mediation, you get to decide what kind of settlement looks good for you. So again, we have to follow Canadian legal system processes, but you get to decide, did they do the right thing? Did they say the right things? Did they offer you enough? Is the symbol the right symbol for you in that time? And that's totally dependent on who you are, what you need, what your goals are. And again, we work with you to make sure that your goals are being met as part of that resolution process. So only if that doesn't work, then we'll schedule the case for trial. And scheduling the case for trial is actually a longer process than that, because what we're doing is we're saying to the court, we want you to set aside a time for the trial to happen. But before that, they actually set aside a date where you meet with a judge before a trial in another confidential setting. And then the judge tries to facilitate a resolution. So she will read the case, she'll read all the evidence, and she'll say, in this circumstances, I would have decided the case this way. And I hope that encourages you to come to a resolution. So that's still confidential. And we have a lot more success if we don't settle at mediation, settling at this. That's called a pretrial conference. Only if we can't reach a resolution throughout that whole process, only then does a trial become necessary. And trials only really happen in one of two cases. If the two lawyers can't come to some kind of agreement, which typically means one lawyer has made a mistake, or if there's confusion about a point of law. So the reason that we have a lot of success with settling cases without needing a trial is because Simona has beat up just about every child welfare agency in Ontario so many times that they don't try to go after her as much anymore. They know what her arguments are going to be. And so they don't, there's no confusion about the law that they want to challenge in front of court. And most of the lawyers that we deal with, they know they don't make those kinds of mistakes. So we have a lot of success with that because none of those two things are really present in our cases. So, but if it becomes necessary, we are prepared to go to trial if necessary, and we will prepare you absolutely for that if that becomes necessary too.
And to put it into context, in all of Canada, there has only been 3 cases that have gone to a trial involving child welfare organizations. One here in British Columbia, one in where? Newfoundland?
Nova Scotia, I think.
Nova Scotia.
Like out of millions.
We don't know.
Not millions, but thousands and thousands and thousands. I mean, I've been doing this for almost 30 years. I've probably had at least 1,000 cases against child welfare in Ontario and other provinces, and not one of them has gone to court.
I'm not
So-
sure if I could say this, but I really think that you must be some kind of like superhuman to be able to do all this. Sorry. I mean, even I don't know you very well, Tom, but same as you two. That's why I was scared coming in because I thought it was going to be a sharing because I don't have that.
No.
I go outside and I'm like I just melted.
Yeah.
How do you do that?
I don't think we're superhuman. I just think we're human. And, I believe very, very strongly in the work that I do. My first client was a child welfare client. She wasn't Indigenous. She was a child welfare client. And I believe very, very strongly in this. And I believe very strongly in the rights of people who were harmed as children. And I have a really good support network around me. And, at times it becomes very difficult, but we take care of each other and we support each other. We have wonderful colleagues that may not do this kind of work. They're within our firm, but they do different work, but we have the support of them. And I have a great dog and a great cat,
Yeah, that makes total sense.
and I've got a great partner.
Yeah.
And I believe in this kind of work. So we aren't superhuman, we're just human, and we want to do the right thing. So that's why we're doing this. And I got to tell you something else. Whenever people come forward, even something like this, for me, it just reaffirms how courageous people are. And it reaffirms that everybody has hope. And it's the most amazing thing to see, right? Because as survivors of sexual abuse, of childhood sexual abuse, all of that was taken away from you. And the fact that you are strong enough to come to something like this, even if you're never going to do anything about it, it shows such courage and such hope and such resilience. And that is a beautiful, beautiful thing. And I want to be a part of doing what I can to help people find that healing.
Every single one of us at the firm has a story like that.
Yeah.
Like I can tell you, it's different for me. I'm the oldest of 5 siblings, and if anybody tried to touch any of them, I wouldn't be in jail fast enough. Let me tell you.
This
So-
is true. She wouldn't. She's vicious.
So for my part, that's the way I grew up. I grew up making sure that people knew that they didn't need to be pushed around by bullies.
I don't know why, but my brain is like going, okay, what if you go to court and you succeed? I feel like, I don't know, like, then afterwards, like, everything's supposed to be better. I don't know if that's a good question.
No.
but-
No, well, let's talk about that, because that's actually, I mean, that's one of the things that we were going to talk about,
Okay.
but we might as well talk about it now. So we've all heard those stories of people getting a bunch of money. A lot of Indian residential school survivors got a lot of money, and a lot of them lost it or used it for things that weren't particularly healthy for them. Getting a bunch of money, all that is that symbol that I talked about. And we try to equip you so that when you get that money, you can do something healthy with it. You know, there are things that are available that aren't available to the regular public. So if you get money out of a lawsuit, whether it's because of a car accident or slip and fall or sexual abuse case, there are things that are available for you to do with that money that I can't do with my money. Okay. So there's things that are available, and we can talk to you about those things, and we can set you up with the people that can help you with that. We can talk to you about, healthy ways of using your money. We can help you find rehab centers if you have addictions issues, for instance, or counselors or this, that, or the other thing. We can help you do all of that, and we talk to you all about that. But at the end of the day, getting that compensation, getting that money is that first step, or it's part of your healing journey. We hope that it is a really important thing for you to look back and go, wow, I did this. I took control of my life again. I took that power back. And for a lot of people, that is a really huge, wonderful, very powerful step. How much ever compensation we get you, even if a judge says, child welfare authorities, you did all these things wrong, you're going to have to pay so much money and bat on you and blah, 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 and apologize and this, that, and the other thing, it's not going to take away that pain. It's not going to take away that hurt. I wish it could. But hopefully, it will be a very good building block for you to take that forward and start to heal from it. Lots of people go through a lot of up and down after a lawsuit finishes. I've heard people say to me, I thought it was blood money. I hated the fact that I did it because it's just blood money. Or I was so happy that I did it because I felt free, I felt strong. And they go from one extreme to the next, sometimes within the next, all within 10 minutes. Okay. That is normal. That is typical. That is something that I hear all the time. Oftentimes, though, what happens is that after you let the dust settle, after you've let the dust settle 3-6 months afterwards, you sort of come to more of a middle ground where you do really see your own strength and your own courage of taking back that power. Because when you're a child, you have no power. Children have no power. And sexual abuse of children and physical abuse of children is taking somebody who has no power and taking even more away from them. But you're adults now. And the fact that you're here talking about this is a step in taking back that power. Sexual abuse of children isn't about sex, it's about power. Sexual abuse of any kind, sexual assault of any kind is not about sex, it's about taking power away from somebody else. And this is your opportunity to take that power back. So that symbol that we talked about, that compensation, that's what it is. It's a symbol. And we hope, and the reason why we do this is to give you that kind of symbol back That's what it's about.
Sorry.
No, it's okay, it's okay. I think our elder's getting some tissue for you.
I would say thank you for sharing yourself with us so freely, because it tells me that you feel safe.
Yeah.
And that's what we're trying to do here, is trying to find a safe way to heal through the justices that happen to us as Native people. And we're with sisters, and we're here with brothers, and our sisters are here supporting you, giving you information.
Sorry.
No,
There's nothing to apologize
nothing
about.
to apologize.
I think it's just, it's been so long that I'm just angry that our province doesn't give us an apology. And it's been so long, and from my opinion, we never had anybody come forward and like you guys to say that you would support us. So that's what I'm crying, 'cause it's just like it's been so long. Does
Sure.
that makes sense.
Hey, it happened in childhood. It is a long time. And I wish I could tell you that we can force the province to give you that apology. We can't force the province of British Columbia to give 60 Scoop survivors an apology. But as part of negotiated settlement, for you individually, you may receive an apology from the government. I have had those apologies come from the Ontario government to my Ontario clients. I've had those apologies come from other provinces to my clients from those other provinces. So that is more than a possibility.
Do you know that if like others who got compensation, like, like, can people get better?
Yeah,
Yes.
Yeah.
absolutely.
Here I am, sister.
I've done so much work.
This is, me too.
Okay,
much.
so as a
And
little
I
boy,
still
I shared this with you. As a little boy, 4 or 5 years old, my 13-year-old babysitter was abusing me, and I became sexually aware at a very young age. I didn't know what I was doing at that time, but as my life progressed, I knew what was going on. The noises that I hear in the house, I know what they mean.
Yeah.
And then as a 60 scooper, a social worker, my male social worker was systematically raping all my foster brothers. And it took him years to work me down, but it was stripping pieces off me. And then when I was 23, I said to myself, I lost a marriage. I feel alone. I don't know where I belong. The name that I'm using doesn't even feel right. So when I was 5 years old, Mikey said, I had enough. I don't want to be called Mikey anymore. And then when I was 23, I said to myself, Mike, that's who I was called then. Mike's had enough. So I spent 3 months trying to figure out what I was going to call myself, because Mike was so damaged. So after 3 months, I settled on Michael. I went through a whole bunch of other names, but Michael is my healing name, my first healing name. And then when I got my Bill C-31, and my whole family, my mom, my dad, my siblings, everybody else, they got we got our status back. Then I started getting involved. And then my sister here, she witnessed me healing. And my sister here witnessed me healing in doing the work in the community. And eventually I was born with 4 gifts. I didn't even know how to do anything with those 4 gifts. I was afraid of those 4 gifts. But as I went to sweat lodges and I got trained, Uncle Sam, George took me, and there was other people, and I had like really strong women that were elders who could talk to spirits come and work on me. And they've lifted all that pain out. And I've shared, I won't get into it now, but I shared with these ladies here. My healing, what I actually had to release the man out of my body in my healing journey, so that I was no longer connected to that social worker. So I'm healed. And I've done a lot of work with a lot of people and I continue. And so that's why we're here. So that sister here says you can, sister here says you can, these two sisters I know, because, and I say that to you, you can, and they've witnessed other people heal. So yes, it's a journey and it's going to take a while.
And for myself, healing for me is what happened will never go away. I've just developed more skills as I heal to be able to get me through the rough times, right? It doesn't mean I don't have bad days and that I don't need to pull all my resources together. It means that I can cope with it on a daily basis now.
Like, one thing that's been really, like with the healing is like, I'm not just First Nation. I'm also half European. So it's like I'm half a person. So everywhere I go, it's like, it's only the First Nation. It's like, yes, but I'm also just as much European.
Yeah.
Yeah, I'm just
Exactly.
saying that like, I feel like when it comes to a lot of the supports are about First Nation and First Nation like smudging and things like that. And it's like, but I'm not just First Nation and that's not all of me. And I feel lost. because
So
I'm a
that's part of your
European,
healing journey. You're going to have to come to terms with.
Right.
So it's all good respect. I want to move on.
Yeah.
Where are we oh, there was a question.
Next question.
My other question was, so we have categories when we're taking from social services. So we have CPS, and then we have the board of the courts.
Yep.
And then we have the adoptees.
Yep.
Mhm.
Okay, so does that cover everybody for this lawsuit? Like, is everybody, if you were just taken from social services off reserve?
Yeah.
And, you weren't a ward of the court per se, because I'm a ward of the court, right? Ward of the province, I know that. But you were just put into that, like, just the town that you were in, say you were Bridgetown or something, and CPS you in that area, but you didn't make ward of the courts. Are we still entitled to all of this? Like, are we all included in this?
Again,
Is it inclusive?
again, it's individual.
Yeah.
So it's not one big group,
No.
No. We need to know more about what happened to you specifically. Then we can tell you what your options are.
People are gonna say, well, court, yeah, okay, and community board.
Yeah.
As per se, and other people, my brother would say, well, I was adopted.
I was saying we're encouraging you to ask the question, right?
Right.
So we're saying what we can tell you is you should at least ask the question, whether you are ward of the court, whether you were only in temporary foster care, whether you were an adoptee, ask the question because it may apply to you. So why not at least ask? Yeah, no problem.
You want to do this one?
So how long does it take for the lawyers to investigate your options for justice because if you're sexually abused?
So the first part of the process, I was talking about the investigative process, that can a few months to sometimes it can take up to a year or two. So it's unusual for it to take that long, but I say it's that people have an idea of what to expect. So sometimes the reason that it takes a really long time is because most of the time when we're looking at these sorts of cases, they're what's called historical sexual abuse cases or historical abuse cases. So historical abuse cases, that's just a special way to say it's something that happened a significant amount of time ago, whether that's 5 or 10 or 15 or 50 years ago. So it's important to say that it's important to know that the lawyer that you're talking to understands how to deal with historical cases, because with those kinds of cases, you have to know how to find records from group homes that may not exist anymore, or child welfare agencies, 40 years ago when they were a different version of child welfare, or, medical records from a hospital that closed down, things like that. So we have a records clerk, and her job specifically is to track down these kinds of records. So her specialty knowledge is she knows how to go to Archives Ontario or go to child welfare, 30 years ago. So that's her job. And so she's hired to do that job specifically because we need to find those records. But sometimes if those records are not where they should be, or they can't find them, or it's taking a long time, or they're extremely big files, they can take a long time to come to us. Like it took me 2 years one time to get a police file, just because the police just didn't want to send it to me. It's taken me a year to find out what happened to a group home that got closed in Northern Ontario. So sometimes it just takes a long time. Sometimes it can be quick though. Sometimes, you call me, I do a bit of an interview, I say what happened. Turns out you have all the paperwork you need already. 6 weeks later, we could be good to go. So it just depends.
What if you reported it later?
That's
Like,
fine
not at
too.
the time?
Yeah. So actually, why don't we talk about the next
Yep.
question and then I'll answer that too.
Can I pursue a civil claim if the police are not notified of the abuse or if a criminal case was dismissed or resulted in a not guilty verdict?
So the easy answer is absolutely. You don't have to go to the police first to report your abuse. In fact, most of our clients have never gone to the police to report their abuse. In many situations, people with a history of childhood sexual abuse don't have a particularly good relationship with the police to begin with. As Indigenous folks, I'm sure a lot of you don't have a particularly good relationship with the police. And there's a lot of distrust there. So you absolutely do not have to go to the police to report your abuse first. Even if you did go to the police, or if the police came to you because they found out from somebody else that maybe you were abused. So even if there was a report to the police, and if that report to the police resulted in a trial, a criminal trial against the person who hurt you, if that person was convicted, that's good for you. If that person was not convicted, or if that person was investigated and not charged, it may still not make a difference as to whether or not you can pursue a civil case. In many situations, even if that person was found not guilty, they were found not guilty because of legal technicalities as opposed to credibility issues. So in situations like that, you can still likely pursue a civil case. Again, because this individual, we need to determine why that person was found not guilty. Whether it has an impact that's important to us or not, we don't know until we figure that out. Once we figure that out, we'll then be able to tell you whether or not it's going to have an impact, either a good impact or a bad impact or no impact whatsoever.
So, also, I did sue. I did go charge for.
Yep.
I was 16 years old
Good for you.
when this happened. You know what they came back and told me?
Yeah.
I was of age.
Well,
I was of age and they closed the case
well, that's not
Straight up.
surprising considering,
because I was 16. I was of age of consent. they
Right.
believe.
right. So,
But it was happened was you were abused by
somebody in power.
yes,
Yeah.
and you have it's a safety comply.
Yeah.
Because of fear,
Of course.
right?
So here's what I can tell you. When you were 16, society was very different.
Yeah.
Okay. Because you're what, like 22, 23 now?
But we all are.
I'm 58.
There you go.
Again,
Yes.
again and again.
Exactly.
This only happened like 10 years ago when
Yeah.
I tried to do this.
That is still not surprising too. The things have changed a lot in even the last 5 years. Okay. Something like that. There are still a lot of very ignorant police officers who will not charge in a situation like that. Okay. The more enlightened police officers and police officers who've received the appropriate training would likely charge in that situation. Okay. It would not surprise me if you went today, you'd get a very different result. Okay.
Because I know that when I went to, like I said, this class action, and I was in school at Dow, and I got the letter of the school, and I opened it and said that. I sent the paper in my head. That started my whole mental breakdown.
Yeah.
Because I felt that, they were harming me more
Of course.
by saying that I didn't,
Yeah.
that, oh yeah, I agreed to this one.
Look, there's a lot of ignorance out there, okay? Part of,
So
part
that's
of,
gonna be part of, like, this is part of what I'm trying to save people from having to
yeah,
go through.
well, that's, sure, and that makes a lot of sense. I wish I could tell you that every police officer out there would do the right thing. I wish I could tell you that every police officer out there had the kind of specialized training that certain police officers get, you know? I was part of the Toronto Police Services Sexual Assault Consultative Committee. And as part of what we did was that we actually created training materials for police officers as to how to deal with sexual assault survivors, especially child sexual assault survivors, you know. And if you are a police officer that wants to work in this kind of area in Metro Toronto, you get that training, right? And I will assure you that every police officer that gets that kind of training would never have talked to you that way. Problem is that that is like 1% of 1% of police officers out there, okay? Your normal police officer is not going to get that kind of training, and your normal police officer probably will say, oh, you know, age of consent 16, you're 16. Okay, sorry, can't help you. Okay. It's when they get that specialized training, and if somebody who actually wants to do the job, you know, wants to do the job and wants to do a good job and gets the right training, they'll make the right decision. But the good news is that individual lawsuits don't matter. You know, it doesn't matter whether or not you got to the police. Okay, so you know, for you, even if you went to the police and you got that answer, you can come to,
So
you can still pursue it.
that-
Absolutely,
that part of your
absolutely,
story
absolutely,
that we feel is the most
absolutely.
important one was denied.
Absolutely. Look, we have had the most craziest things. You know, I had a situation about 4 years ago now where a lawyer representing a Children's Aid Society, and I'm not kidding you, a lawyer representing the Children's Aid Society stood up in court and tried to argue that my client was a sexually mature 14-year-old woman and therefore consented.
Well,
Okay.
wait,
So that lawyer is currently being disciplined by the Law Society. That lawyer got fired from that job because all of a sudden somebody was saying, hey, wait a minute, what you're saying is crazy. It actually made the front page of the Toronto Star. You know, you can Google it. All right. What we're doing here is spreading information. You know, for 30 years, we've been spreading this information. For 30 years, we've been saying, you know, childhood sexual abuse is wrong, and this is wrong, and you can't do it. You can't do it. This is why we have these information sessions. This is why my law firm, part of what we do on a daily basis is our work for individuals, but it's also advocacy. You know, it's why we work with the police to train these officers. It's why, you know, we go to this and that and the other thing. So whether or not you went to the police and got a good or bad answer doesn't matter. The civil courts are different.
So can you sue if your abuser's passed away?
Go ahead.
so you can likely still sue the institution, depending on if this institution is liable once we do the investigation. It doesn't matter if your abuser's passed away, if we can hold the institution liable. If your abuser's passed away in 2 years, like in the last 2 years, you may also be able to sue the abuser's estate. So depending on whether or not it's worth it though. Sometimes it wouldn't have been worth it to sue your abuser anyways, because maybe your abuser doesn't have assets, or we can't find them, or, you know, they won't be able to answer, or they're too sick to know that, you know, they need to own up to what they did. So sometimes it doesn't even matter. What we really want is we really want to say, look, it's an institution put this abuser in a position of authority over you, and they were responsible for supervising you and keeping you safe. So really, the institution's the one that should be held to account for letting that happen. If we can add the abuser, and if, you know, they'll show up, we will. But you don't need to be able to sue them in order to sue the institution that was responsible for you at the time the abuse happened.
Can I sue if there are no witnesses?
Yes, yeah. So I don't think I've met anybody that's had a witness to the abuse happen.
I have.
Simona has. I'm obviously younger than Simona, just by a couple years, as you can tell. So.
My hair used to be pink.
I got it from her. It doesn't matter whether or not you have witnesses. And I want to make an important point here. When you see people talking about evidence on TV or this or that, typically they're talking about forensic evidence or, video evidence or whatever. That's supporting evidence. So sometimes called corroborating evidence. All that does is that adds support to what you're saying. What you say is evidence. So when you tell your story, especially under oath, that's testimony, and testimony is evidence. And Simone and I have both successfully resolved cases, and I've won cases where the only evidence that I had was the person's story. So you don't need to have witnesses in order to be able to go ahead with your case. And in fact, most people don't, because sexual abuse is a crime of not only violence, but of secrecy.
So what sort of fees are charged by lawyers to assist me with an abuse lawsuit?
Yeah.
What are you gonna charge me for this?
Wow, lucky me. So our law firm, our law firm, if you come to us, we do the cases on what's called a contingency fee basis. So contingency fee means it's the classic, we don't get paid unless you get paid type situation.
That's pro bono. No.
It's different than pro bono. So pro bono means that we don't expect compensation at all,
Okay,
but it's kind of like pro bono because there's no upfront fees.
that's right.
So we're not charging you anything. You don't have to pay us. We cover all the costs of everything. So court filing fees, process servers to get paperwork served, mailing, printing, photocopying, all that stuff. So we cover all the costs and expert reports. Yeah. If we need to get you assessed, or if we need, a doctor to talk about why you have chronic pain, we pay all of that. So the way that we get compensation for you is we get typically an insurance company that's working for an institution to pay a settlement. And then we'll take a percentage of that, and then you get and then pay off the expenses as well, and you get the balance.
Okay, so how much percent?
So we charge the Ontario standard, which is 33%. And the firms that we work with here, we understand that they're in the same range as us. So they do the same sort of work on the same fee basis. And if you want to contact us so that we can help arrange that with the other firm, like we can try to work things out with another firm. Obviously, they're their own institution, so they have to make their own choices, but that's what we do. And that's what, we've talked to all of them. That's what we understand that everyone we work with does as well.
So
So we
that's
take
the
a third of it.
33%
Yes,
and the cost of the actual
lawsuit. Yeah. So like
filing,
expenses.
logistics and court procedure stuff.
That's right.
So you're talking
I see.
two different things. Fees that we pay out of our pocket
Yeah.
are what we call disbursements,
Okay.
Right,
disbursements.
which can be anything from court filing fees to
Yeah.
cost of expert reports, things like that. And then there's legal fees. Those are two separate things. Your legal fees are, if you choose to hire us, 33%.
Yeah.
On top of that, disbursements will be reimbursed. So, if we've spent $1,000 on court fees and whatnot, we're reimbursed for that.
Okay.
Settlement?
Yes,
and,
Through the
uh,
settlement. Now, in most situations, as part of the settlement, the amounts that's negotiated is the amount for you, plus all of the disbursements are
Okay.
paid back. Plus, usually what happens is that they chip in some money to help you with legal fees,
Okay.
right? But what will happen is that if we receive an offer to settle your case, right? We will talk to you about that offer,
Yeah.
and we'll tell you whether or not, from a legal perspective, we think it's a good offer or bad offer or an okay offer.
Yeah.
And we also tell you, once everything is paid for, how much you get in your pocket. So there are no surprises.
Okay.
So even though, the number may be 100, right?
Yeah.
We tell you, yes, this is good. No, it's bad. It's okay, mediocre, whatever else. And by the way, that 100, after everything is paid
Yeah.
for, you actually get 100
Nice.
minus whatever,
Yeah.
okay?
So-
So there are no,
So if I,
usually it's a little bit more, it's usually about 15,
so if I wanted to end up with 100
right?
for myself.
Yeah.
Then we would sue for 133,000 plus disbursement.
Yes.
Plus disbursements, plus legal fees, things like that.
I didn't know
So that would
that
be
part.
So,
Yes.
Well,
What you're
ask
saying
for
is you
that.
could do that. and-
Well,
Yeah,
ask
yeah,
for
of course.
the
You don't
legal
ever pay
disbursement.
anything out of your
Oh, yeah.
pocket. It all comes out of
Yeah,
the
you have to
lawsuit.
ask.
Right.
Yeah, so that's why the institution is important, because insurance companies, they're typically, unfortunately, sophisticated enough to know that. So they know settlement plus
Okay.
legal fees plus disbursements plus this and that. So, and we do try to minimize the amount that comes out of your pocket. So they pay, we try to get them to pay us, we try to get them to pay the expenses, all that.
Yeah, they
And it's
generally,
not out of your pocket, it's out of your pot of the money.
Yeah.
Yes,
Yeah.
out of your pot, sorry.
How much are the disbursements generally?
it's really impossible to say. I have had cases where my disbursements are $50,000.
That's what I was thinking.
I've had cases where my disbursements are 500.
Yeah.
Typically, for a child welfare type case, it's usually somewhere between 5 to 10,000. If it is more than about 10,000, it means that we are pretty close to trial, because that's when we need to bring in the big guns for the expert reports, and there's usually more than one expert report in this, that, and the other thing. Expert reports can run anywhere between $5,000 to $15,000 per expert.
And it doesn't matter what the value of the case is. I've had extremely high value cases with minimum disbursements, and I've had cases that, you know, probably half the case value was in disbursements, but thankfully we got the client a lot
She
more.
was saying you can ask in the settlement to have the disbursements.
Paid
paid
back,
for.
yeah.
Yes.
And is that common?
Yeah, absolutely, absolutely. I mean, what generally happens is that, you know, we try to negotiate. We start off by saying, you know, we want, just to make my math easy, okay, 100 for the client, plus we want, you know, 30 for the legal fees, plus we want another 10 for all the disbursements, right? So we don't want just 100, we want 140. Thank you.
So
Right.
wouldn't you want to pad that just in case you
Yeah,
got
it's
closer to
140.
This is,
the?
yeah, no, this is sort of what, yeah, like when we go into a negotiation, we don't say what we want, we say what we want plus
Okay.
room to negotiate,
Yeah,
right?
yeah.
I mean, it does
There's a whole
become,
strategy.
there's
Yeah.
a whole strategy that is dependent on the individual case. It's sometimes dependent on who's sitting across the table from me.
Yep.
Right,
So
because
how
they're,
long are you ladies in Vancouver for?
We're leaving tomorrow.
we're leaving tomorrow morning.
Oh, I better
However-
go get my files.
However,
I can email it to you.
yeah,
Yeah.
so, you know, we're in town only until tomorrow, and then we're off to Victoria and then Nanaimo. We've been on this roadshow now since August.
Yeah.
And it's about time for me to go home and
Oh,
take
can
care
I
of my
get one from
animals.
my friend Kelly?
Um,
I have lots.
But, there are
Oh,
two
well,
things.
Probably one for Gary.
We forgot to bring in the stuff, the
Uh,
forms.
Do you know, give me their email, I can write down your email afterwards too, so.
Okay,
So if you want, you can either contact us, or if you want, your contact information and we'll contact you. There is
My
no
card.
rush. Please understand this, that this is not a, you know, please give us your name and number and blah, blah, blah. There's no rush. If you want to take a week, a month, a year to think about,
Will this, like, as we know, I lost track. The child welfare class action's just been approved, right? For the
Millennium School, yeah.
Yeah.
And a lot of 60s people also qualify for
Yep.
that class action.
Yep.
Will that affect,
I doubt it.
okay,
So that one was about, so I did check on that one, so that about your human rights tribunal, like your human rights being violated because on reserve child welfare funding was not
And
provided
reserve
appropriately.
too.
Right, but it was about the funding that was, so it was technically, so, well, let's talk about the Canadian legal system for a second. So in the Canadian legal system, we've broken down your rights into a bundle of things. So you have some rights under the charter, you have some rights under the Education Act when you go to school, you have some rights under the Highway Traffic Act, right? You have some rights under the blah, 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 blah. So under the Human Rights Code, that's where they've housed all of your rights to be free from discrimination and harassment and sexual harassment and, you know, maltreatment on the basis of race and gender and color and sexual orientation. So under the Human Rights Code, you have, if these rights are violated, you have these options, right? So in this case, the one option you had was to go to the Canadian Human Rights Tribunal under the Canadian Human Rights Code and say, my rights in this box were violated. I checked, and I used to be a human rights lawyer, and I still do some human rights work. So what this compensated individuals for was what's called injury to dignity damages. So this is what the Human Rights Code violation damages are called. That's separate and apart from what we're talking about. What we're talking about is individual traumas. So we're talking about pain and suffering, loss of ability to earn income, and care costs for things like therapy, medication, things like that. I could have taken your Human Rights Code and put them into a lawsuit. So all they've done is they've taken away this one extra option you could have had in your lawsuit, and they've put it over here instead. That's the only difference.
Sorry, can we get compensation for family members?
Yes and no, it depends on the family member and depends on when. So in most provinces, you as an individual, your family can also be part of your lawsuit if the family relationship existed at the time that the harm was caused. So to give you an example, the easy one is this. Your family that was alive at the time that you were harmed, they possibly can get compensation for what's known as loss of care, guidance, and companionship. The fact that you were harmed means that they were harmed. Your children, because they weren't alive at the time that you were harmed, they unfortunately are not part of this lawsuit.
What about like our spouses, like how our lives have affected them?
No, your spouses are not, that relationship didn't exist at the time that you were harmed.
So you're saying siblings that were separated and didn't get to grow up together could sue for that?
As long as they were alive at the time
Okay.
that the harm was caused. So
Because a lot of us
older
were taken and
siblings?
put into separate homes, right?
yes, absolutely, absolutely. So any relationship that existed that was an existing relationship at the time that you were harmed, those people can possibly sue as well.